on or about June 16th of 2024, you did knowingly make an open or indecent exposure of your person while fondling your genitals in a public area.
I do not identify. I identify as the beneficiary that is here to protect Derek Stringer. I said, how do you charge a dead entity, sir?
I'm sorry, say that again?
How do you charge a dead entity, sir? And
it just happened right before your eyes. Good luck to you.
This courtroom starts off like something straight out of a late-night comedy skit. But trust me, it's all too real. On June 16th, 2024, a man named Mr. Stringer was hauled in for 2 counts of indecent exposure. The allegations? He was caught in a public park fondling himself. Yeah, this is the kind of case where you almost wish it was made up. But instead of taking his charges seriously, Stringer goes full sovereign.
Stringer does not acknowledge or consent to this hearing. Is that correct, Mr. Stringer?
I do not identify. I identify as the beneficiary that is here to protect Derek Stringer.
Very well, Mr. Stringer. The court is going to read the charge into the record since the formal reading is not waived. Mr. Stringer, on or about June 16th of 2024, you did knowingly make an open or indecent exposure of your person while fondling your genitals in a public area, contrary to the statute so made and provided at Michigan Compiled Law 750.335A, subparent 2, subparent B. The court advises you that this is referred to as a Tier 1 offense under the Sex Offender Registry Act. There is a count 2 misdemeanor in that on the same date you did knowingly make an open or indecent exposure of your person contrary to the statute so made and provided at Michigan Compiled Law 750.335A, subparent 2, subparent A, commonly known as indecent exposure.
Sir, excuse me, sir. You have not talked to my beneficiary yet. You have not talked to the person who owns the estate yet.
Mr. Angot, the court is making a notation of court-appointed counsel to run through the IDSO office, and that new counsel, as appointed by Mr. Mena, can make whatever judgments they wish to make and make any motions they wish to make at Mr. Stringer's first probable cause conference. Mr. Stringer, this matter is now being set for a probable cause conference. That will be on a new date. The law entitles you to what they refer to as a preliminary examination within 21 days of this arraignment today.
He also has a lengthy criminal history out of Texas, going from as recent of these warrants, which were entered last year, back to around 2015, receiving charges for evading arrest and detention, unlawful possession of a firearm by a felon, assault, family, house member impeding breath or circulation, several other assault charges, a weapons charge, and then also like falsifying assault from 2019 out of Markwood Woods, which looks like it was deferred as assaulting a public officer or obstructing.
Judge, despite the fact of these charges and what was listed by the detective, I believe that with the GPS tether, that certainly would give this court, pretrial services, and any other entity overseeing Mr. Stringer during the pendency of this matter, notice of where he would be within 3 feet, is my understanding, with that tether. I don't think a cash bond is necessary. I would ask the court to give him a personal bond with the GPS tether.
Given everything that's before the court at this time, the court will set bond in the amount of $50,000, cash or surety, no 10% allowed at this.
Citizen. He refuses to acknowledge his own name, insists he's just a beneficiary protecting an estate, and even tries to argue that the court is charging a dead entity. The judge, who's been through this rodeo before, keeps his cool and reads the charges anyway. And honestly, watching Judge Urich handle this nonsense is a masterclass. While most judges get flustered by this sovereign citizen word salad, Urich just keeps shutting him down with precision. The charges themselves are no joke. 2 counts of indecent exposure under Michigan law, one of which even qualifies as a Tier 1 offense under the Sex Offender Registry Act. On top of that, this guy has a rap sheet from Texas that looks like a small novel. Weapons charges, multiple assaults.
If Mr. Stringer wishes to bring various motions before the examining judge and That could include a motion to modify his bond. That is his right and his privilege, but at this time, that is the bond as set by this court. Mr. Stringer, that concludes your arraignment, sir.
Sir, so I can't get out on a personal bond?
That's correct, Mr. Stringer. You cannot get out on a personal bond. 50,000 cash or surety with the appropriate conditions that were already listed by the court. That completes your arraignment, sir.
Sir, so what is going on with the, what is going on? Right?
I'm sorry, sir?
I'm being charged. I'm being charged with entity that is.
Can you please move up so the court could hear you?
I said, how do you charge a dead entity, sir?
I'm sorry, say that again?
How do you charge a dead entity, sir? And
It just happened right before your eyes. The court has jurisdiction over you, sir. Venue and jurisdiction have been established by sworn testimony. That completes your arraignment. Good luck to you.
We're about to go to war.
Assaults, evading arrest, even attacking a public officer. And yet here he is, pretending like he's too clever to be bound by the law. So the judge hits him with a $50,000 cash bond. No 10%, no wiggle room. And honestly, it's the right move. The last thing anyone needs is a man with this track record and this level of delusion walking around free. But Stringer? He's not done yet. As the hearing wraps, he blurts out something that leaves...
All right, Mr. Stringer, state your name.
I don't acknowledge myself as Derek Stringer. I'm a living entity.
Okay, is there another name that you go by, sir?
Living entity, I am the beneficiary, so I go as a job. And I want to fire that counsel. I don't want him.
All right, so there's a number of things to unpack here. All right, so let's walk through this. So did he make it known to you that he wished to no longer proceed with your services?
Judge, we discussed the case fully, and I had a lengthy phone call with one of his relatives, and it was my intention to ask the court to refer this to the Forensic Center for a competency evaluation.
I do think it, given your experience and then your connection with him as well as a family member, plus the way the defendant has presented today, that a competency review is in order. And so I'm happy to move forward with that. So Mr. Stringer, there is, just so you understand, there has been some preliminary information that suggests that you may not be competent to proceed at this particular time. Whether that's a correct assertion is basically a decision that can only be made after an investigation is done to determine whether or not you can, that you understand the nature of the proceedings, that you can assist your attorney. We need to find those things out. And so, Ms. Mott-Lewis, can you prepare an order for competency review?
Leaves everyone stunned. We're about to go to war. Yeah. He actually said that. To a judge. Now we move into a second hearing, and this time a different judge is on the bench. And right from the jump, Stringer doubles down on the crazy. He refuses to state his name, calls himself a living entity, and insists on firing his court-appointed attorney. The problem? The attorney actually spoke with Stringer's relatives and was about to request a full competency evaluation. And honestly, who can blame him? This defendant clearly doesn't understand what's going on, or maybe he just doesn't want to.
To consider that request until I can determine whether or not he's competent. If I would remove Mr. Sanutko off the file, if I would remove him off the file based on a request made by a person who's later determined to be incompetent, I think that would be a real issue. And so at this point in time, I'm going to grant the request.
What labels, excuse me,
evaluation.
What labels me incompetent? My intelligence, because I have a high IQ?
No. That's not it, sir. There are different legal standards, but really it comes down to whether or not you can understand the nature of the proceedings at this time, that you have the ability.
I overstand the nature of the proceedings.
That you have the ability to assist your attorney in your defense.
To withdraw, sir. I do not want my legal counsel. Actually, he did not reach out to the person that my relative told him to reach out to my father, and he didn't do that. My father was going to tell him that we wanted him to withdraw. He did not reach out to my father. He only reached out to Stephen Taylor. Stephen Taylor gave him my father's number, and he did not do that. So I would like him to withdraw from my case, sir. I have no. So he doesn't. He isn't competent enough.
Either way, the court can't move forward until they know whether he's even competent to stand trial. So the judge orders a competency review, and you can practically feel Stringer's ego shatter in real time. He tries to argue his high IQ makes him perfectly capable, but IQ doesn't matter when you're standing in court yelling about dead entities and beneficiaries. Competency is about understanding the process and being able to help your lawyer. And right now, he's failing on both counts. At this point, it's pretty clear where this is heading. Either he's mentally ill and needs treatment, or he's another self-proclaimed sovereign citizen who thinks a few buzzwords make him untouchable. But when you've got a history of violence, weapons charges, and now indecent exposure in a park, your excuses don't mean much. The judges here actually handled him with restraint. Some would have thrown him in contempt the second he threatened war. Instead, they gave him due process and set the wheels in motion for a competency evaluation. Whether that buys him more time or seals his fate, we'll have to see. But I'll be honest, if you ask me, this isn't just a man playing games. This is someone either spiraling into delusion or so deep into the sovereign citizen rabbit hole that he thinks the law doesn't apply to him. And either way, that's a dangerous combination.